entertainment attorney Stephanie Haig here with Stroke of Genius Law, and today I want to come to you all and talk about producers' ownership in the sound recording, better known as the masters. So we're going to break it down into basically what I call like the rule and then the realities of how it's really applied and what really happens, okay? So before we get into that, let's remember there are two vested copyrights in a song. There's the performing arts copyright, which is the PA copyright, and that is a combination of the music plus the lyrics. That's the songwriter's copyright. But then there's also a sound recording copyright, which is the music plus the lyrics plus the artist's performance of those elements, and the combination of those three elements create what we call the sound recording copyright. Okay. Also note that as a producer, you can have a vested interest in both. You can have an interest in the lyrics or the music if you help to create either or. And you can have a vested interest in the sound recording, and that's what we're about to get into. So your vested interest in the sound recording comes because if, for instance, the artist comes to you and says, hey, I went and bought this beat offline, for instance, okay? And I have some lyrics that I put to it, but I need some help laying it all down in the studio and combining it and putting it together to create my final mastered version of it, okay? Well, your collaboration with that particular artist inherently creates the masters, and in the creation of that masters, it creates your copyright interest in that particular sound recording. So that is really how your interest in the sound recording is created. It is not necessarily your contribution to the music or the lyrics. It is simply that your skill set has helped this particular artist bring all these elements together and create a final version of the song, which we all know is called the masters, okay? So that's the rule. Your contribution and skill set to the song creates, to that final recording creates your vested interest, your copyright interest in that masters. Now, the realities of this is, and really where the exception comes in, is that the producer oftentimes signs a producer's agreement. In this producer's agreement, there's a work for hire clause. That work for hire clause is a transfer of your copyright. Why do you say that? Because the work for hire clause basically says, hey, we want to take your copyright and we want you to transfer your copyright over to us. We've commissioned you to do the work. And because we've commissioned you to do the work, we want to pay your producer's fee and or producer royalties. And in exchange for doing so, we want to own what would have been your copyright, or what is your copyright in this master recording. It's a transfer. You sign over the agreement, they pay you your producer's fees, they give you some royalties, and bing, bang, boom. All of your copyright interest in this sound recording is no longer. You have transferred it over to either the artist or the record label, okay? So that's the realities, and that is how producers don't realize in the signing of that agreement that they have transferred over their copyright in the sound recording, in the masters, okay? So I also want to note here, if you are working with indie artists who do not have representation, who are not signed to a label or what have you, and so you're not working directly with the label to send over, for instance, a letter of direction for your royalties or what have you, you and the artist need to be very clear about ownership of this masters. Are you all going to be joint owners of the masters, or is it their intention for them to pay you whatever fee it is, and then for you to completely own, or not you, I'm sorry, for the artist to completely own the masters, and for you to completely give up your ownership of the masters? Know what the intention is, because attached to copyright is your money. In any form, attached to copyright is your money. Understanding what your interest is in this sound recording is directly related to your coin, basically, okay? So just to recap right quick, the rule is you are an owner of the sound recording if you go into the studio and you help to create this final mix master version of the sound recording. It does not matter if you did not assist in the creation of the lyrics or the music. If you assisted in the final version, you own a portion of the sound recording copyright. The realities of it is, if you sign a producer's agreement, most likely that producer agreement had a work for hire clause in it, and that work for hire clause was a request to transfer your ownership in that master recording to whomever the party was that was listed, and in exchange there may have been compensation via producer's fees and later producer royalties attached to that. Okay, so that's our rule and that's our reality. I hope you all found something interesting and found something helpful in this video. If so, please like, share, and repost. Post all your comments. I love to see them. And until next time, bye.